Is your ex hiding assets, and what are you supposed to do about it? Well, today's episode will be great for you because we're going to be talking about all the scenarios where people try to hide stuff and what you can do about it. Welcome, Mum.
Hello, Laura. Hi, everyone.
So I've kind of poured all these questions we get all the time about different ways of hiding assets into one episode, and I'm just going to fire you with lots of questions, but we're going to talk about when they drain the money from the account and it just disappears. We're going to talk about hiding their super. We're going to talk about when they put it in trust funds. We're going to talk about cash in hand work. Hopefully, we can also talk about when they sell it to their mates or their family, disappearing assets, hiding assets overseas, and also hiding assets from child support or just not doing disclosure. And then we're going to talk about how you can deal with it before mediation and how you can deal with it if you're in court.
Wow, that's quite an agenda. Let's get cracking.
Yes. Okay. All right. Let's get to our jingle and let's get into it.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
Now, before we start, we need to remind you that Mum isn't your lawyer, and this is Australian family law. And every situation is different. So please just see this as a little bit of education about what the law is, and you can then get a lawyer to help you apply it to your situation. All right. So, Mum, one of the things that happens right at the get-go is draining the account money. So they've got like a joint account and the money just gets sucked out. What are people's legal rights? Is that gone and there's nothing they can do, or is there something they can do about it?
Well, it depends on what the money's used for, okay? And if it's used for reasonable living expenses and they can prove that, then it won't get added back in if they can't support themselves on their own wage. But if they just take it out of the joint account, as of the 10th of June, the court will be looking at adding that back in. They have to consider that, and they have to consider what they've done with the money. So it might be that it's overseas trips, and we've all had that. Post-separation savings get counted, post-separation spending seems to be all right. If they drain half the money or all the money out of the account, generally I think people should grab their own share of it and maybe grab your share first. It depends who's in the most powerful financial position going forward. And you're just putting it in for safekeeping if you think the other person's going to take it. But don't do it if they need it to live on.
So basically you're saying as of the 10th of June, 2025,
yep,
there are going to be some changes that look at it differently.
Yes.
And if it's just living expenses, if they're just spending the money on
normal living expenses, then
they can't be added back.
As long as their salary doesn't cover their normal living expenses. Do you know?
Gotcha.
So the court's going to have a good hard look at what's done post-separation. It should stop that sneaky gripper grabbing that some people do and leaving their ex with no support.
Yeah, because we do hear of these certain horrible people that they make like $200,000 a year. There's a joint bank account, and all of a sudden they're just spending the money in the joint bank account for holidays and overseas trips and everything else, buying a new car or buying fancy shoes. Yeah. So that is something that happens a lot.
It is. And the court's dealt with it in the past by looking at contributions and considering the money that a person might take and waste as a premature distribution. What the changes to the FCFCOA court procedures and the Family Law Act mean is that the judges have that written in now, and they can specifically look at that. It gives the court not a strict pathway, but it reminds the judges to consider it. It usually says the court is to consider, and then it lists all these things. And one of them is what's happened to money post-separation.
The next thing that happens a lot is superannuation. They say, you can't touch my super, and they just don't give them any information about the super. They say, no, screw you. I'm not giving you my super. I'm not even giving you any information about it at all. And that's hiding an asset, really. So what can people do in that situation?
Well, I'm thinking of people who don't want to have to go to court to do subpoenas or get them to deliver documents that way. Everyone can use what's called a Form 6, a superannuation information form. And I think there's a similar one in WA, but I'm talking about the eastern states and central states here. And as long as you've got an idea of the name of the super fund, and most people, I don't think I've ever come across someone who doesn't know the name of the usual super. You can put that in, put the other person's name, date of birth, send it off, and you will get your information back.
You don't even need their membership number?
Nope. No one, hardly anyone ever has the membership number. So you put their name and date of birth. Yeah, so that's a good, quick way of getting an answer right off the bat. Now, if they've opened a fund you don't know about, you should be able to see money going into somewhere that you don't know about. And in that case, you may think about starting proceedings. If you file an initiating application in the court for property settlement, one of the things that you can fill in is a superannuation questionnaire, the Australian Tax Office, and you can do it on the portal. And you put the name and date of birth of the person and ask them for all the super funds or any of the super funds that they are connected to. And the tax department, who are great mates with super funds, and they're right over the governance of the superannuation funds, will send you that information. I often do that search just as a double check, even if there's no suspicion, because it doesn't cost you anything once you're in the court, and just check. And then maybe I'll check again later to see if they've started a new one in the proceedings.
So the portal you're talking about is the ComCourts portal that's set up by the FCSUA. So that option is there for anyone who has a file number and it's in the court. The other option is a SIF form, Form 6.
Yes.
All right. So that's that one sorted.
Yes.
What about, and we hear this one all the time on social media, just put it in a trust fund, mate. So a trust fund is like a company, anything kind of legal thing that means that the property isn't owned by the individual, it's owned by something else.
Yeah.
So how can people get that at least looked at in property settlement?
So that's a tricky question. And with trusts, they may work with the tax department who will say, oh, you didn't earn that. The trust earned that, so we'll sort the trust out later. But the Family Court of Australia and the WA courts as well, they've got jurisdiction to be able to what they call tear apart the corporate veil. In other words, have a look behind it and see who owns what and who's the beneficiaries, who are the trustees, and then most importantly, if any of you are looking at a trust, the important person is the principal or the appointer of trustee. So if you've got the power to appoint a new trustee, then that trust is yours and the court doesn't care whose name is on the other bits. You can appoint anyone as trustee, and there have been cases where the court has ordered someone to appoint their ex-partner as the sole trustee of the fund so that they can get it sorted through. So people think they're clever, but they're not that clever. And this has been going on since Ascot Investments and Harper, which is a case way back in the 80s about property, and it was in a company, and they're going, what are you going to do about that? And the court said, let us show you what we'll do about that.
Maybe that's a case you should do for Patreon.
I may have already done it, but if I haven't, remind me and I will. It's a good one.
Then that gets us to businesses, Mum.
Yeah.
And we hear this a lot.
Oh, yeah.
I've helped my ex with their business forever, maybe bookkeeping, or I was looking after the kids. I didn't get involved in the business, but I have no idea how much it's worth. And my ex says it's none of my business.
Yeah. Okay, let's just take that back to I've helped with the business. If the business was started while you were a couple, then you both built that business. You didn't help your ex. You worked the business. Your ex worked the business. You grew the business together. So there's one mindset to shift. Don't follow their guidelines or their narrative as it's my business, it's nothing to do with you. And the court also says that contributions in homemaking and parenting are to be considered, and not in a token way. They are really an important way that a person contributes to the assets of a marriage, because if one of you wasn't looking after the kids like they did, the other one wouldn't have been able to devote so much time to the business. So that's Mallett's case. That is on Patreon. Yeah, so there's that. And then it's a problem when the other person thinks it's all theirs. But look, just hold strong, guys, and insist on evaluation. And insist on evaluation that's a proper one, that if someone would buy it, go through your formal channels. You can do that before court. You can send them a panel of 3 valuers, get them to choose one. If they won't, then when you go to court, you can dob them in to the judge, ask for costs. But the number of people I've had that story, if you make me pay you out, it'll ruin the business. But they've all been wrong, and they're all seeing it through the paradigm of keeping everything the way it was and just remove you from the equation. But it doesn't work like that. So you go and you take your share. And I've had someone just recently where the parties had almost agreed to put the money in the kids' names or in a trust for the kids, or put it in a child support trust. And it sounds lovely because you're looking after your kids, but what about you in the meantime? And so you can leave your share to the kids when you go, but you don't have to live in poverty until such time. So the court doesn't make orders that give those properties to the kids.
Okay. All right. Good to know. Those sending them a panel of 3 valuers and asking them to choose a valuer, can you do that before mediation as well, or just before?
Oh, you must do it, really. You can't have a proper mediation about property unless you know the cost. And there's all these different ways of valuing a business. It might be like, how much are the desks, the chairs, the fridge, whatever, the cars, how much is that worth? Or how much return is someone getting on their investment? If they invested in the business, are they making money? How much money are they making? And so all of those, so that earnings before tax and interest is one way. Valuing assets is another way. So the valuers not only value the business, they make an assessment which methodology to use. And also it saves you knocking yourself out trying to get documents from the business, from your ex, because the valuer will just go in and go, okay, show me the books for the last 5 years or whatever it is. And if they don't cooperate with, the valuer gives a report on them. When you go to court, my goodness, on the first return date, there's usually cost consequences.
Okay. If you are interested in learning more about valuations, we have a great episode called Untangling Valuations. Go and listen to that. We talk you through the step-by-step process of how that all works. Another one we hear.
Yeah.
And these are more the tradies, not the office people, but this is the tradie version of the office people's hiding assets. And they do it all cash in hand.
Yeah.
So they may be earning big bickies, and now all of a sudden they're earning nothing, and they're just getting paid in cash. Their ex is messaging us saying, I think he's getting paid in cash, or I think she's hiding it all in cash. How does that, and what can people do if they think that?
Okay.
It's happening.
Yeah. So there's the leading case on that sort of issue is Weir and Weir. And I'm pretty sure I've recorded that on Patreon. And it's the one where there was a quarry, and suddenly the husband didn't earn any money or hardly any money. But when the valuers went out to have a look, the hole was much bigger than it should have been for the amount of gravel he'd been selling. And I don't know if it was ever proven, but the court regarded him as having either delayed payments until after the court case was over, or got it in cash and hidden it somewhere, or running a second set of books that they didn't know about. But anyway, they just added it back in as a premature distribution of assets. So that's one. But if you don't have anything like a smoking gun like that, then it's a lot trickier. So one way to do it is look back over previous years. And if there's a sudden drop in their income, that might make you think it's cash. Be very careful. I don't encourage anyone to break the law or conceal assets from the tax department. But if it has been happening with your knowledge during the relationship, think about whether you really want to raise that issue now. First of all, it looks like you've agreed or acquiesced through the way. Even if you didn't, you've had the benefit of tax-free income over the years that you've been together. And if the court gets wind of this, they may, and often do, adjourn the proceedings, refer it off to the tax department, so the tax department can find out how much money actually is owed to them, and then that becomes paid to them, and your property pool diminishes accordingly. I'm not going to say anything else about that.
Okay. So go and see a lawyer about that. So basically you're saying if you've been letting it fly and you knew your ex has been getting cash in hand while you've been together, you can't really change your mind later and get upset about it. But if they've swapped over to cash,
that's different.
And you change, you can say, hey, look at the difference.
And even if you didn't know, through the relationship that they were doing these dodgy deeds, the court will say you've had the benefit of that extra income unless they didn't put their income in the family pot, so to speak. So it's a very grey area. So go and talk to a lawyer.
Okay. Thank you, Mel, for clearing that up.
Is it clear though?
You've made that clear, yeah. So what about selling stuff to mates? We hear about this a lot. They've got like this hotted up mirror, I don't even know cars, but and then they sell it to their mate for $50 or $100 and it's actually worth $5,000 or they've got a lot of mowers and stuff and they just give it to their friends and say, here you go, give me $1.
And they've been bragging about how much it's been worth. Oh, that car's worth $70,000. And then it's only worth $10,000. It's only a 1974 Holden. Do you remember the little Escort I had, the little 2-door Escort coupe? It was shocking. An old car. Now they're selling for tens of thousands of dollars.
Are you serious?
Like a lot.
Seatbelts were metal and they burnt my leg.
And it had little 2 doors. Yep. But no, it's...
Is that the one with the Michael Jackson tape stuck in it where we just had to listen to Thriller all the time?
I'm sorry. Yes, it was.
Okay. Yes. Sorry. Okay. So old cars are worth stuff. And if they clock it off and then say, I sold it for $100, what can people do about that?
Well, first of all, it may have only been worth $100. So you need to find out what other vehicles of the same were selling for. Sometimes those good old cars are being insured. They'll only be insured through a couple of companies in Australia. I think Shannon's is one. And because most insurance companies won't touch them because they're not as expensive as the people. They don't think it's as valuable as you say it is. It reminds me, if they sell it to a mate for a lower price and you can establish that it was worth more, the court, this is their attitude. And you've heard me talk about Townsend's case before. That was a premature distribution of assets, i.e. they gave themselves the fancy car or the motorbike or whatever. And what they do with that is their problem. But when they took it into their own possession, it had this value. And if they say it was worth 80, and if they choose to sell it to someone for $500, that's their loss. But $80,000 is going to go in on their side of the ledger. And that's how they work it.
Wow. So you've got your two sides of your ledger.
Yeah.
And you're going to say, you took that car, it was worth $80,000. So you've already had $80,000. So when we do property settlement split, that's already on your side.
Yeah.
So $80,000 left you have to give them.
Yes. Well, it goes, the $80,000 goes into the whole property pool. So your house minus the debt, your, boat, whatever, furniture, and the hot rod, $80,000, whatever that car was. And then when the court divides that up and works out who gets what percentage, the very first item on their ledger will be they can have the hot rod at $80,000. And when they go, but I sold it for $500, the court will go, well, maybe you shouldn't have.
Wow.
And of course, they're right. The court has identified a behaviour to get a bigger share of the property pool and to defeat their ex's claim.
So can you do that in mediation or do you have to wait till you get to court?
No, you can do your Red Book searches or your carsales.com searches and get a rough idea what it was worth. And then you take that with you to mediation. And when you do your list of assets, make sure you or your lawyer remind them to put the hot rod in at $80,000. Okay.
Right. So I guess this goes into the next one that we were going to talk about was disappearing assets. I guess it's the same thing. If the assets disappeared and they say, I don't know where it is, but you knew what it was, you could just get a rough value and put it on their side of the ledger.
Absolutely. You don't have to show where it went. You just have to show you had it. And look through old photographs, look through old bank statements, get the proof it was there, put it in confidently as an asset, and they will pretty quickly tell you what they've done with it. And they have to prove what they've done with that money. Right. And so a lot of people get tangled up in I can see this money going out. I don't know where it's going. It doesn't matter where it's going. This money's going out. It's their obligation to explain what they did with that money, not your problem to find it.
And you just put that dollar amount on their side.
Yep.
Until they can prove otherwise. Right. So what about hiding assets overseas? We do hear this a lot. Right. So what about hiding assets overseas. We do hear this a lot. People have maybe sometimes pensions or houses or boats, cars, other things, bank accounts overseas. How do people deal with that?
Well, it's tricky because we don't have, our court doesn't have jurisdiction overseas to issue subpoenas. Usually there's a limited number of subpoenas types of subpoenas you can issue. It's very technical. Talk to a lawyer. But that avenue is generally not available to you. You can go on the website, say for UK pensions or whatever, and they have like little tables. You can calculate roughly what that pension's worth. You can't split an overseas pension, but it can go in as a financial resource. So you can do that. You may have photos of said house, car, boat, whatever, put them in at what you think they're worth. They still have real estate. They have real estate websites in other countries. Just find out what it's worth and put it in. If they've sold it or it was gone during the marriage or relationship, they'll pretty soon prove it to you. If not, until it's proven otherwise, that's an asset and you just add that in. But every now and then, someone manages to hide assets overseas successfully. And there was a case recently where the parties had spent many tens of thousands of dollars trying to find this one wife. The wife, I think, was trying to find the money. The husband just wouldn't divulge, wouldn't say anything. And in the end, the court gave the wife every single asset in Australia that they knew about. And that was the best they could do. Yeah. It just depends how much there was overseas. Yeah. And having properties in some countries isn't a real advantage. Like in some countries, if there's war going on, if you can't own it unless you are from that country. There's things like that. There's other countries that have complex leasing arrangements. So all of those things need to be done. Sometimes it pays to get a lawyer in that country to run a valuation for you, to appoint a valuer and get that over to you. Sometimes the clients themselves go back to the country and get some proof.
Right. So, I mean, we do have that checklist before you go. And I don't know if anyone's going to be listening to this, if they probably all have already left. But I think one of the big lessons from this is go and, if you can, while you're still together, take photos and documents of the things that prove that things exist, bank accounts, details, all that sort of stuff. Yeah. If you can get that before you go, the better, if it's safe. Now, Mum, another thing that people do is they just don't do disclosure. They just don't do it.
Oh,
and they might not, like, it's just not done.
Yeah.
And people are coming up to mediation or they're coming up to court and they're stressing out the amount of messages we get from people saying my ex isn't doing disclosure.
I've seen them. Yeah.
So what?
Need to start doing your disclosure but have no idea where to start? Feeling overwhelmed about mediation coming up? Or just trying to deal with negotiating with a manipulative ex? Then you need to go to thedivorcecourse.com.au to go to the free resources section where you can get a mediation checklist, a disclosure checklist, a word salad, read a letter like a pro checklist, and also a before you go checklist. Get ahead of the game and be organised and ready, as this handy checklist, along with the accompanying episodes of the podcast, will be perfect for you. All you need to do is go to thedivorcecourse.com.au and go to the free resource section and download the free checklists today.
What can people do about that?
Well, first of all, a little bit of good news. So up until now, disclosure has been, the rules for disclosure have been contained in the rules, and it's been talked about in the Central Practice Direction. As of, I don't know if it was immediate or anyway, as of this year's amendment, they're going to become actual sections of the Family Law Act. So that's important. If you can't find out the truth, then you're entitled to get the information before the court the best way that you can. And with disclosure, you may have to go to court. You may have to get a judge to order costs against them before you having to go to court. You may have to go to court and then issue subpoenas all over the place to get that information. And again, ask the court for costs because your ex has failed in their obligation to be always up to date with disclosure. So it doesn't mean with disclosure that you should get a letter or get an updated bank statement every day or every second day. But every month, all of these things should be updated. Don't waste too long. If they are not going to give you disclosure, you'll know that pretty quickly. And it's really not worth going to mediation if you don't know what the property pool is. If the disclosure that you're missing is about a detail and it won't really change the overall result, maybe you can go to mediation with that. But if it's something significant, you don't want to be kicking yourself years down the track for not asking the question and not getting the answer.
I heard the most bizarre situation the other day. Someone said to me their ex had provided their proposed agreement of percentage split, but that they hadn't done disclosure. And they'd given them 2 weeks to respond and said, you need to respond to this. And they were like, but how am I supposed to know percentage of what? I don't know what the disclosure is. And we've done a great episode on the pitfalls of negotiating percentages before you know your property pool. And if any of you are in those situations, go listen to that episode because there's some super nasty tricks that can happen if you agree to a percentage before you know what the actual property pool is.
Yes.
But Mum, I feel like there should be a better catch for people because this seems to be the main sticking point for a lot of people with high conflict or manipulative and control.
Or avoidant person.
That's true.
They are really going to step up against those sort of people now if they won't make their disclosure. You have to remember that even consent orders need disclosure now. It's a part of the Family Law Act. And how can a judge or a registrar make an assessment that a property distribution is just and equitable? And I would say that's fair and reasonable if they don't know what all of the property is. So if they're only dividing up some of the property and they've got no idea how much the other person has, they won't make an order. And interestingly, I've been scouring through the legislative changes and they've changed one word that's going to mean a lot. There's a section that says the court shall not make an order about property unless it is just and equitable. And they've changed the word shall to must. That's the only change in that sentence. But now the court must not make an order unless it is just and equitable to do. And the only way they can find out if it's just and equitable is to have that disclosure and find out those things. So I think there'll be punishments for people, mostly cost punishments. Also, I think the court will be looking at people's lawyers because what they've said to us in the practice direction is that if our clients are not complying with disclosure, then we should not continue to act for that person. Because if you do continue to act for that person and you end up in court and try and defend not giving disclosure, you might end up with getting your backside kicked because lawyers are officers of the court after all. So I think you'll find people who are into those shenanigans are going to find it harder and harder to find a lawyer that will cooperate with them or turn a blind eye. Yeah.
Right. Okay. The last place I see people hiding assets and I get complaints about is in child support. So there may be people who they have lots of amazing assets there, but then they don't work or they're just rigging the system so that it looks like in their tax returns they're not making much money. What can people do about that side of it?
Well, that's a mouthful of issues just really in one go. So the Child Support Act deals with a lot of that stuff. Okay, so it's no longer usually the province of the court unless the wheels really come off the whole thing. And the Child Support Agency and the Tax Department are also very good mates. And it depends. If their taxable income is coming in low, then the first assessment will just be based on that low income. And you have to do something. You have to ask the agency to reconsider and give them reasons. And I think there's 10 or 11 reasons. We had that amazing girl, didn't we?
Crystal. Yes.
Oh, yeah. Amazing.
So go and listen to that episode because that's really good. And you really pretty much have to apply for a change of assessment for one of the reasons. And one of them is like, it's unfair.
Yeah.
So go and listen to that episode if that's you. But Mum, in a nutshell, people can either go and do their own sleuthing.
Yes.
Or they have to go to court.
Yeah. Look, it's 50 years since the Family Law Act came in, right? 1975. I think we're 50 years coming in now. And the court has been spending a lot of that time tweaking the system. And I can promise you there's almost nothing that ever comes before the court that hasn't been seen or tried before. And experienced lawyers like me very rarely find anything that we haven't dealt with before and we know how to fix it. So you do have to go to court, though, to do it. you can't, court can't punish a person unless you've got an application before the court and you drag them up to get, it's like taking them to the principal's office. But remember, going to court is not always like an inevitable trial several $100,000 later. Going to court is just, I think you should look at it as, yes, if this mediation doesn't work and we're going to be playing silly about property disclosure and hiding assets, then I'll go to court because I can use the court's tools. I can ask for cost orders, but from the bench, they may give cost orders against the other person to make them behave. You can issue subpoenas when you're in the court. You can look up their superannuation when you're in the court on the court portal. So there's a lot of ways there you can gather your information, even if they are uncooperative. And in Townsend's case, I understand that there wasn't a lot of cooperation coming from the person who owned the extra big hole in the ground. But that didn't stop the court making a finding of what it was worth. They found out there was about $100,000 worth of stuff missing and awarded the wife $50,000 out of the remaining assets, compensate her for that. And they both appealed, I think. And the appeal court said, look, we're not going to interfere with the judge's discretion. If he thought 50-50, that's fine. However, we may have been more robust, they said. We may have been more robust. And I think someone said we'd have given all of it to the person who wasn't hiding it.
Wow. All right. But if they're leading up to mediation, can they use the pre-action procedures and just threaten court? Will that sometimes push people to do the right thing?
Yes, or sometimes refusing mediation until, if you're on solid ground. I'm a big, as these dates come up, they may stall and hope to talk you into a settlement at mediation because, I'm there. And so what you do, I'd encourage people to tell their lawyer or ask their lawyer to write one letter with just a few lines in it that says clearly as anything, we're set down for mediation / court on this date. We require these documents, number them, and we have requested them on and put the dates in a row as well on the 5th of November, 24, on the 6th of December, 20. And at a glance, the judge or the registrar is going to be like, hang on a minute, why didn't you? And it just completely puts the ball back in their court. But you don't have to get sucked in to a mediation when you don't know the property pool. Because I can tell you, if you do reach consent orders, then after the 10th of June, the court can't make those orders unless they are convinced it's just and equitable. So you're going to have to put on your side of the ledger the assets that you say are missing or unvalued, and you might have not known. Well, once that goes into the court's going to go, well, I can't make any orders until I know.
And we do get this question, so I'm just going to chuck it in there.
Yeah.
If people don't have a lawyer, can they write a letter asking for disclosure themselves to them?
Yes, and use that format I just said, okay, so that it looks, so don't clutter up a lot of other writing, okay? Use headings and a column, and headings and a column. And don't ask for 1 million documents. Yep. You might even put the date of the document you want, and why you need it, right?
Right.
And that sort of tells your whole story. And then if you're self-representative or in court, that tells the story. You request on these dates, and that would make, I think, anybody respond, because what are they going to say to that?
Brilliant. Well, look, I know this was a bit of a quickie, but we wanted to just go through all of them and just kind of explain what people can do, because I know some of you out there are pulling your hair out. Mm-hmm. Thank you, Mum, for giving us a little run through of it all. We do have some really good episodes on DIY disclosure and disclosure delays, where we talk about the different personality types as well. We didn't have time to do it today.
Yeah.
But just be mindful of, just keep in the back of your head, is your ex avoidant? Is there something you can do to help them get the disclosure done? Because maybe they just can't bring themselves to do it.
Yeah.
If they're manipulative and controlling, how can you speed up that process? Because the longer you leave it, the longer they're going to be hiding stuff, and the harder it's going to be to unpick. If they're high conflict, if you get this sorted, the sooner the better with the facts. You can stop a high conflict person with the facts. So there's just some things to think about. But Mum, I thank you again for all your lovely information. Reminder that this is not legal advice. This is just education. And keep writing in and letting us know how you're all going, and we'll keep making these episodes.
Good luck, everyone. Bye, Laura.
Thanks.
Thank you. See
Bye.
ya. Bye. Bye, darling.
If you found this podcast helpful, we'd love it if you could rate, review and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.